Hi everyone, and welcome to the NG Podcast. I'm Marcus Ineson, your host. In the NG Podcast, we hope to bring you content that's of interest to anyone involved in enteral feeding, whether you're a healthcare professional, a patient, or a carer. Here we go. So usually on the NG Podcast, we deal with the clinical aspects of nasogastric tube safety, but this week we thought we would look at it from a different perspective. What happens or can happen legally when a never event occurs and someone dies or suffers injury as a result? We're joined this week by Monia Sood and Elizabeth Wallace from Hill Dickinson LLP. Hill Dickinson is an international law firm of market-leading legal experts specialising in all aspects of commercial law, from non-contentious advisory and transactional work through to all forms of commercial litigation and arbitration. They've got offices in the UK, mainland Europe and Asia, and Hill Dickinson provides services across three broad business groups, one of which is the health business group, which both Elizabeth and Monia are part of. Elizabeth, Monia, thank you for joining us today. We really appreciate your time. So first of all, I wonder if you could briefly explain your roles and how you get involved in a legal process following a never event.
Thanks, Marcus. I'm Monia Sood. I'm a legal director in the health litigation team in Manchester, and my role is to deal with clinical negligence claims following an injury or death.
So I'm Elizabeth Wallace. I'm a senior associate in the healthcare advisory team in our Manchester office, and my primary work involves representing NHS trusts, who are generally our clients, at inquests following a death.
I appreciate that every situation is different, but can you talk us through how a case develops following a never event? Monia, maybe if you want to start on that.
So the trust is likely to launch their own internal investigation. It's known as an RCA, or a root cause analysis. And by its very nature, it's a systemic process for identifying the root causes of an incident, and it has a specific approach for responding to them. So the RCA is based on the premise that any problems or issues should be prevented. And the aim is obviously to learn lessons. And normally the contents of that RCA will then be shared with the patient or the family. So the trust will then report the claim or the potential claim to NHS Resolution. So they're an arm's length body of the Department of Health and Social Care, and they provide indemnity insurance to the defendant trusts. So then my team will then be instructed by NHS Resolution to act on behalf of the defendant trust. And it's important to remember that the defendant in any clinical negligence claim involving an NHS trust will be the trust itself and not the clinicians. But obviously, it's really important that we get clinician input when we're trying to determine the merits of the claim or the defensibility of the claim and what happened. And once we're instructed, then we'll liaise with the trust and obtain any evidence so we can determine the merits and the steps that need to be taken.
Elizabeth, is there anything you want to add to that at all?
So from an inquest point of view, a death as a result of a never event would usually constitute as an unnatural death, which means it would have to be reported to the coroner. And it's at that point that we would get involved if the trust want support with the inquest process.
Okay. And if we can sort of look at that a little bit more. So after a death is reported to the coroner and a date set for the inquest, what happens in the run-up to that in terms of preparation and perhaps how a clinician might be involved?
So firstly, I think it's probably worth me just explaining a bit about what an inquest actually is, just to put things into context. So it's important to remember that an inquest is a fact-finding that's led by the coroner. Usually the coroner's sat alone, but sometimes the coroner might be sat with a jury, certain types of cases. Okay. There are 4 key questions that the coroner needs to answer. So who the deceased was, when did they die, where did they die, and the question of how did they die. Mm-hmm. So in order to answer those questions, the coroner will request statements from clinicians who were directly involved in the patient's care leading up to the death. And it's at that point where we often get involved in terms of supporting our clients with those. And in order to assist those clinicians with their evidence, we'll support them in preparing very detailed statements for the coroner. And if the coroner, having reviewed those statements, wishes to hear further evidence from that clinician, then they may well be called to provide oral evidence at the final inquest hearing. So it's really important that the statements are really detailed and prepared well, based on the actual medical records. So we'll always have a good look at those and make sure that any pertinent entries are reflected in the statements that are obtained from clinicians. In terms of other preparations ahead of the inquest, if a clinician has been called to give oral evidence at an inquest, we'll try and meet with them beforehand just to make sure that they are prepared for the hearing, know what to expect, know the sorts of questions that they might get asked, because going to any sort of court is really quite a scary experience, and there's a good chance that clinicians have never been in a court before. So we do make sure that we provide a lot of support to them. Another thing in terms of the preparation, as well as statements, the witnesses are encouraged to be aware that the findings of any internal or external investigations that have taken place, whether that's a root cause analysis investigation or some sort of independent experts investigation that's taken place, because it's really important that witnesses are aware of any lesson learning as a result of a death, because the coroner might ask them about, and it might have a direct impact on their own lesson learning as a result of a death.
Sure. And you, I know you said that if the statements are sufficiently detailed, sometimes the coroner may not call them as witnesses. But if they are called to give evidence at an inquest, is that like giving evidence in court? Is there that cross-examination piece that we so often see heavily dramatised, or is it different to that?
So this is something that I'm often asked by the witnesses who I'll meet with before an inquest. A lot of people watch TV and they get this impression that it's going to be like some sort of US court drama, where there's going to be a lot of shouting, a lot of people saying, "Objection, Your Honour." The coroner's court is not like that. It's supposed to be non-adversarial, because the coroner is just looking for the factual information of the events that have led up to a death. This is because the coroner can't apportion any amount of civil or criminal liability on any named individual or organisation. So that's not the purpose of an inquest. Having said all that, I have come to a number of inquests where families have perhaps instructed barristers who are more used to cross-examination in a civil or criminal trial environment. And unfortunately, they've kind of taken that stance and those skills into the coroner's court. So sometimes witnesses are given a bit of a grilling, but they shouldn't be. And, we'll step in and support that witness if it's starting to go down that track. So,
So assuming that doesn't happen, or, perhaps if it starts, the coroner stops it. What does that discovery look like? If it's sort of not adversarial, how do the questions come? Does the coroner ask questions, and then do the lawyers get their chance?
Yeah, so the coroner will ask questions first, and then any of the other legal representatives will have the opportunity to ask questions. So the order it generally goes in is the coroner will ask questions first, and then the family will have an opportunity to ask questions. And then it always ends with the legal representative who is actually representing that witness, who will have an opportunity to ask questions. If the coroner's impaneled a jury, they'll have an opportunity to ask questions of the witnesses as well.
That sounds much more exciting than being a juror in a normal court.
Yeah.
I'd probably quite like to do that.
Same actually.
At the end of an inquest, what are the possible outcomes if in a clinical case, or a never event case?
So in terms of the inquest outcomes, the primary outcome is the actual conclusion to the inquest. So that used to be called a verdict. It's a bit like a judgment to the court case. That can take two main forms. So you can have short form conclusions where it's literally just one word or a couple of words. Examples of that would be natural causes, accident, misadventure, suicide. In more complicated cases, the coroner might provide what's called a narrative conclusion, which is basically a short paragraph, usually just a couple of sentences long, which states in factual terms the events that have led up to a death. For those types of conclusions, the coroner can also include contributory factors to a death, and that needs to be proved on what's called the balance of probabilities, which is the civil standard of proof. Best way to describe that is it's more likely than not that this has caused the death.
Yeah.
So in terms of a never event, if it's found that that never event or medical error has actually contributed to the death on the balance of probabilities, it's likely the coroner will record that in the narrative conclusion. So you can imagine for our clients that we represent, that's obviously not a great finding if their medical error has actually directly caused the death, and it's in the conclusion to the inquest. Another role that the coroner performs at an inquest is they also have a protective duty to make sure that similar deaths or there isn't a continued risk of future deaths in the future. So the coroner can provide what's called a prevention of future deaths report, also known as PFD or Regulation 28 report. It all means the same thing. So the coroner will issue that to an organisation who is able to take steps to minimise the risk of death in the future. So the coroner will only write that report to anyone who they believe can actually take that action.
Okay.
So that could be an NHS Trust, or it could be NICE or the CQC or Department of Health, whoever is best placed to deal with it. Those reports are important because they are published on the judiciary website. Right. So the general public and the media, anyone can read them, and you only have to go on their website and you'll see them all there. Right. The recipient of those reports has 56 days in order to provide a written response. Obviously, the impact of those reports being available for anybody to see is that potentially the press might get hold of them, and there could be bad publicity about the inquest and the NHS Trust that was involved in the death. In terms of some other slightly uncommon results that you might get from an inquest, but I have seen them in a few that I've come across, is if there are questions concerning the conduct of some of the clinicians involved in the events leading up to the death, then the coroner may make referrals to the GMC or NMC, which they will do if they don't feel that an NHS Trust has actually taken steps themselves to discipline a clinician. If the inquest is high profile, perhaps the family have already been in touch with the media and the press before the actual inquest takes place. The press might be at the final inquest hearing because inquests are usually held in public. There needs to be good reason for them to be held behind closed doors. So anybody can attend an inquest and listen to the evidence and can, write articles about the conclusion afterwards. So you can imagine in terms of a never event where the conclusion is critical of the care that's been provided, that could potentially get into the public domain, and obviously there's bad publicity that results from that. Making referrals to the GMC and NMC, the coroner can also refer a matter back to the police following an inquest. So that could be to investigate possible criminal offences, which usually in the context of a healthcare related inquest, that could be gross negligence manslaughter if there's been an error by an individual clinician, or it could be corporate manslaughter if the coroner believes that the trust have actually failed on a systemic level to prevent the death. So there could be criminal investigations that flow from an inquest as well.
Oh, yeah. Okay. Thank you very much. So we've gone through the inquest. We've got the cause of death. We've got if there's contributory factors. So when the inquest is over, if a claim for compensation is made, how does it proceed, and would a never event being involved affect that process?
A claim is usually brought via the claimant's solicitors, although you do sometimes get litigants in person. But once we're instructed, then we'll review the internal investigation. We'll obtain or meet clinicians to get their views on the case and to obtain a statement. But I think in light of it being a never event and the fact that it shouldn't have happened, it's likely that with sort of trust approval and NHS approval, that an early admission of liability would be made. And so the focus would then be on the value of the claim, and we try and settle the claim as soon as possible. Obviously, the trust would have a duty to be open and carry out their own investigations. They'd apply the duty of candour and then share the findings with the claimant. That's sort of how we would get involved from the outset of the claim.
Okay. But if that doesn't happen and it's settled, if it does go to court, and sorry if I sound a bit obsessed with US courtroom dramas, if that goes in and there's a compensation claim and it goes to court, is that a more adversarial environment than it's supposed to be in the coroner's court?
Yeah, I suppose by its very nature, litigation is probably more adversarial than what would happen in a coroner's court. But again, NHS Resolution are clear that they don't really want to take cases to trial unless they really need to. Yeah. And certainly in a case where it was a never event and an early admission was made, then we would never recommend taking the case to trial. Sometimes if you aren't able to agree on the valuation of the claim, then you might go to trial on the quantum issues. But if you then the clinicians wouldn't be involved in that process. So it would just be the medical experts that you instructed and the solicitors and barristers. So the clinicians, once admissions of liability are made, then the clinician's involvement basically comes to an end.
Okay. And I know I sort of set that up as after the coroner's court, a claim, but can they run in tandem, or be started, overlap a little bit, and does that have an impact at all?
So yes, they can run in tandem, and one thing that is always really beneficial for an inquest is if it becomes very apparent that an error has been made in the care. It's always really helpful to have an early admission of liability in relation to the claim. The reason why that's helpful is because we can advise the coroner of that admission of liability, and that will narrow the scope of the inquest in terms of what questions the coroner needs to investigate. Because if there's been an admission of liability, that issue has been dealt with. It's effectively the trust have put their hands up and said, yes, we've made that error. We accept it. It's uncontroversial. So the coroner doesn't need to delve into it further for the inquest. It's just out there. It's accepted. That can be really helpful for actually the final inquest hearing, because the coroner might limit the number of witnesses who need to be called, because we just don't need to explore certain issues. And also the witnesses who have been called will probably have less questions to answer. And the family, if they've got legal representation, again, they probably won't have as many questions to ask the witnesses either. So it could turn a week-long inquest into like 2 days. So it's really helpful to get that. And one final thing in relation to early admissions of liability is that it could potentially save costs later on down the line, because families, rightly or wrongly, it is quite controversial. If there is a early admission of liability, the family might not be able to recover the costs of their legal representation at the inquest. I think the reason behind that is because essentially you've had your admission of liability, need legal rep there in order to explore that further.
Yeah.
But it's a bit of a controversial area, that, because obviously a lot of NHS trusts might have legal representation, and it might mean that the family end up without.
So we've been through those two processes. Is there a difference in how you approach a never event case? Is there a difference in the way a court treats a never event to the way it treats other medical negligence claims?
Basically, never event cases are approached in a very sort of similar way to any other clinical negligence claim. It involves an investigation and an assessment of the merits or the defensibility of the claim. But whereas we usually obtain independent expert evidence in a clinical negligence claim to determine whether or not the care was of a reasonable standard, so i.e. whether there was a breach of duty of care, and what the causative effect would be. So those are the two sort of legal tests that you need to satisfy. In the case of a never event, it's likely that breach of duty would be admitted subject to trust HSR approval, and certainly the findings within the coroner court would also contribute to that. There can still be some live causation issues which need to be investigated. And if that was the case, then obviously we'd still need to get some independent expert evidence. Obviously, we'd advise the other side what we were doing and why we were doing it. So just by way of an example, you could have a very premature child who needs assistance with feeding, so has a nasogastric tube which is inserted, and then subsequently it's found that it was not put in the right place, and the child develops a brain injury. So and the nasogastric tube had been put in the right place, then obviously we would make that admission. We got trust and NHSR approval. But it might be that there were other causes of the brain injury. So it could potentially be the fact that there was prematurity or genetic issues or anything like that. So if that was the case, then obviously what we would need to do is get an independent expert evidence, such as a pediatric neurologist, and they'd be able to determine what contributions both the separate events are likely to have caused. Sometimes there'll be no causation. So it really just depends on sort of the individual circumstances of each of the case. But like I say, with the never event, then obviously an admission would probably be made at an early stage, and then the rest of the case would need to be investigated.
Thank you very much. It's great to have an NG tube example there. In the last patient safety alert that related to misplaced NG tubes from NHS Improvement, there is a requirement for every NHS organisation to have a named director responsible for ensuring all the guidance concerning NGT Never Events is implemented. Are there any additional implications for an organisation or individual if an NGT Never event occurs because of this?
I think Liz is going to deal with this in a bit more detail, but I just wanted to point out that obviously the concept of never events is not about apportioning blame, but it's obviously just to learn from what's happened. So this is why, following consultation, when the never event policy and framework was published, the option for commissioners to impose a financial sanction was actually removed. So the guidance does make it clear that removing the financial sanction shouldn't be interpreted as a weakening of the effort to prevent never events. But obviously what they wanted to focus on was actually learning from the occurrence.
Sure. And Elizabeth, do you want to comment a little bit more on that?
So in terms of the patient safety alert from NHS Improvement, another possible implication of the need to have a named director for the implementation of NG tube guidance is the fact that we've actually got somebody to hold accountable for when things go wrong. This could potentially have implications in terms of criminal investigations that might stem following a death, which can result after an inquest or immediately after the death if the police become involved at that point. So for corporate manslaughter, one of the things that the prosecution need to establish is to identify senior management being somehow at fault if there has been a failure to implement guidance. So if we've actually got a named director, you can imagine from the prosecution's point of view, that makes their life easier in terms of identifying that director was part of senior management and they've not implemented the guidance.
Okay, so every trust should have one, but they're kind of a bit in the firing line if something happens.
Yeah.
If in my very blunt layman's terms. So there's also over the last year been a HSIB investigation into placement of NGT, and they've issued an interim bulletin, and we believe the final report is imminent. What would be the impact, if any, of this on a court's view of an NGT Never Event in the future?
So the interim bulletin, it has provided some interim safety observations. Appreciate it's only an interim report at the moment, so the final one is awaited. But nevertheless, it's important that trusts do take notice of those observations, because you never know, they might form part of the final report and also be taken on in terms of national guidance in the future. So there's definitely something to be said for trust to pick up on any sort of developments in patient safety, because they may well become part of national guidance later on down the line. And coroners are interested to know about developments in patient safety, so might be minded to provide a prevention of future deaths report to encourage the adoption of those safety measures.
And also, Marcus, this would probably have an effect on any sort of subsequent claim which might be brought by the claimant and or on their behalf by their family, as they may well also be judged by the new standards. So slightly on a vested interest question here. Suppose there was a new method of improving patient safety is available and is not adopted, even though the method doesn't yet appear in national guidance. Could that be taken into consideration in a case? So in a claim for clinical negligence, the standard of care that is applied is the standard of a reasonably competent clinician, and we would normally instruct an independent expert to say whether or not the standard of care provided was reasonable, although the body of medical opinion that's relied on has to have a logical basis. So the practice is what was the practice at the time of the negligent treatment. So obviously that's why that becomes important.
In terms of if there is a new method of improving patient safety, from an inquest point of view, if it's not part of national guidance, it's unlikely the trust will actually be criticised by the coroner for not adopting it, because it's not, they don't actually need to. However, coroners are always really interested to know about new methods of patient safety, and they definitely won't hesitate to provide a prevention of future deaths report to NICE, for example, to encourage them to actually make sure that this new method is put into national guidance. So like I was saying before, really, there's definitely a benefit for trust to take notice of new patient safety measures or improvements that can be made, and taking steps to implement them sooner rather than later, because they could become part of national guidance in the future. So hopefully that helps.
It does, yes. I think it's the message to us is get NG Pod onto national guidance as quickly as possible, so that it can be used. Well, listen, that's been brilliant. I really enjoyed the conversation this morning, and I really appreciate you giving us the time. I have learned absolutely loads. I will be putting it all in my CPD file, apart from anything else. So thank you very much for your contribution. It's been really great, and we look forward to talking to you again in the future at some point. Thank you very much.
Thank you, Marcus.
Thanks for having us.
Okay,
Thank you.
we hope you enjoyed this episode, and if you do, please subscribe or like on whichever platform you're either viewing or listening to this on.